So it's recording now, and shall I just put the slides on for you?
Yes, thanks.
Okay.
So we've got some slides as well that we'll work through tonight. I'll make some introductory comments in a moment. And
where is it?
yeah, screen sharing.
Yes. Where's the screen sharing?
Yeah, well, I can see the screen. That's it. Perfect. Yeah, well done, Ines. This is what you're there.
And where's everyone gone now? You're all missing from our screen now, so that's fun. That's okay if you mind not seeing it.
No. Good evening, everyone. I'd prefer to if we could.
I'll put it around.
Yeah.
Top right corner, maybe you might be in speaker view or rather than gallery view.
Might be. No, I don't seem to be in any view at all.
So I'll just start talking while Ines is doing that, if you don't mind. Thanks very much, everyone, for your attendance and participation.
Yeah.
I guess there's a
Hang
few.
on, can I interrupt? Sorry, Paul.
Yeah, please.
On my screen, if you scroll up, it pops up view options.
Yep.
And it says there's a side-by-side mode, which might be what you need.
Oh, are you comfortable, Paul, with everyone being here? Can you all see each other?
Can you?
Yeah, I can see everybody and Paul's slides, but if Paul wants to see everybody, that might be what you need to do.
I can see everybody, but I just can't see myself.
Again.
Oh, sorry,
No.
I can. That's all right. That's
Yeah,
fine.
right. I'll shut up now.
No, thank you. So I guess the two topics for tonight are returning to work and mental health in the workplace. I just want people to take a couple of key points out of these seminars rather than trying to throw a whole lot of information at you. You will already have received the slides, and so there's a little bit of detail in the slides about some of the main points. I just want to start with a couple of important things. One of the first themes that I want to emphasise in terms of return to work is about communication. So when we're talking about returning to work, we're talking about injured workers returning to work. And it's about the employers and those representing them, including the insurance companies, the case manager, the return to work specialist and so on, communicating with the employee. So generally, it's in the employer's interests to get everyone back to work as soon as they can in a cooperative manner. And so it's, as I say, communication and ongoing communication, speaking to the employee, making sure that they, hi Jamie, making sure that they know all about their rights and you're adjusting their program as they improve from injury. So that's what I would call a cooperative process that works between the employer, between the injured employee's doctor and treating professionals and so on. But sometimes there's doubts about the genuineness of claims that are made for work cover by employees. And in those circumstances, you might question maybe the injury didn't happen at work, maybe the injury isn't as serious as the person suggests, or and you can have an independent medical examination take place of the employee. So there's different ways that you can look into that, but generally employers have to be careful about being against an employee's claim unless they've got clear evidence about those things. Suspicion is not enough, and it's very easy to fall into a pattern of discrimination against the employee if you don't believe that their work cover claim is genuine. In terms of mental illness and wellbeing in the workplace, I guess the things to be aware of now is how prevalent mental illness is as an issue. We've got a Royal Commission that's going at the moment in Victoria, so there's big changes to the funding in terms of mental health, both in society and also in the workplace. There's a greater awareness of things that cause mental illness in different workplaces and different public spaces. We had child abuse and so on, and that makes people vulnerable later on in their lives and so on, including once they reach the workplace. So, and people can be more subject to bullying if they've got mental health issues and so on. So it's something employers need to be aware of, and I think by having an awareness, it improves the workplace. I think that the important thing also about mental health that I want to say tonight is that you can really start from basics in terms of helping to destigmatise the issue of mental health, because I think traditionally there's a lot of doubts about the importance of mental health and whether that's a genuine injury. And I can remember 10 or 20 years ago where you'd say, I'm having a mental health day, which is sometimes a bit of a sickie, I'm just sick of work or whatever. But maybe in those days it was a genuine mental health day. It was that you were worn down from work and so on, and not necessarily having an injury or anything like that. But I think that we need to be much more open to the consequences, and serious consequences, and we'll go through some cases later on. But it's just having that openness about mental health and just treating it like another injury. If someone has a broken leg, we accept that you need to get that better. In the same way, if you've got a mental injury, opening your mind to that type of injury, and we need to make that better. And I guess it's also probably a bit about asking a few extra questions, because when we say to people, are you okay? They say, I'm fine, yeah, I'm good. And the suggestion is that sometimes asking a few more questions of people is helpful and appropriate in progressing an awareness of mental health. So as I said, there's a number of slides. I won't read them all in detail, but I'll just touch on some key points from them. And there's a couple of key summary slides at the end of each section where I'll really emphasise some of the points. Okay, so they're the topics that we'll be covering in tonight's seminar over the course of the screens. Can you get the, yeah, thanks. So in terms of injuries at work, employers have legal responsibilities under the Accident Compensation Act and to comply with the Workplace Injury Rehabilitation Compensation Act. That's a nice mouthful. Injured employees only have to come back to work when they're well enough to do so, and they're entitled to access occupational rehabilitation programs to help them in that transition back to work and to improve their health and to return to work.
This is going to give us a little bit of trouble.
Yeah.
Yeah.
Okay. The employer has an obligation to hold the injured person's job open for 12 months, and then the employee can either return to work in that job capacity during that 12 months if they're capable of doing it, or another alternative job to which the person is able to return with lesser responsibilities, lesser burdens, perhaps on lesser days, and so on, depending on the health and the recommendations of the medical practitioners of the employee. There can be modified duties, there can be modified workstations and various other things. And I just pause for a moment to remind people, if there's questions as we go, I'm happy to be interrupted, so please unmute yourself and ask those questions. I'm very happy to address those as we go. In terms of occupational health and safety, there's a range of laws that relate to that. So essentially, employers have a duty to provide a safe working environment for everyone. And there's various obligations under the Occupational Health and Safety Act, which carry various penalties, most of them being financial penalties. But I just had a look before we came up on the screen to some of the penalties, and that they can be up to hundreds of thousands, and one of the penalties was in the millions of dollars for corporate breaches of the OH&S Act. So they can be quite serious. Employers need to protect the health, safety and property of any person, including the injured worker. However, an employer can also refuse to employ an injured worker or refuse to allow them to return to work, provided that they've got valid reasons to do so. And the obvious reason might be consultation with medical practitioners and getting medical advice that it's not safe for the person to return to work, whether it's safe for that person themselves or whether that creates a safety problem for the others in the workplace. Importantly, there's a return to work checklist. You've got 6 points on the page here, so I'll leave you to look at those because the next following 3 slides or so go into a little more detail about those various points. And again, probably this comes back to my opening point around communication and information and just doing your homework and keeping notes and so on. Because I guess the extreme cases are where someone can take legal action against a company, whether it's because of discrimination, whether it's because of an injury they sustained in the workplace, or whether it's for some other breach of workplace laws that they assert that they weren't supported by the employer. And if you've got notes, if you've gone through a proper process, then you've got a good defence for yourself. And I guess just as a side note as to that, it's important also for the employer to show that it's taken reasonable precautions overall to prevent various types of conduct that can cause injury in the workplace. In other words, having policies in place, providing education and ensuring compliance with all of those rules. And so returning to the return to work checklist, this is part of the process of ensuring the workers' ability to return to work under following a process. So if you haven't been through this process before, it's a list of things that you can do. And forgive me for those who've gone through that return to work process before, you'll know most of this already. So generally when a worker goes on extended leave under work cover, they require a certificate of capacity, which they get from a general practitioner. That's generally operates for a month at a time. And so they return to their work to their doctor each month. The employer may or may not get a copy of the certificate of capacity. Sometimes that goes straight to the medical practitioner, sorry, to the insurer for the employee to be paid their wage that would come each fortnight or month to the employee. The certificate of capacity provides information about the nature of the injury or illness. It says whether the employee can or can't do certain things. It gives an estimate of their date for return to work and the type of assistance that they need for their recovery. If there's no workers' injury claim form, then if the worker consents, the employer can contact health professionals for the employee to seek further information regarding any workplace support aids or modifications to the workplace that can be taken to assist the employee to get back to work quickly. And obviously that's for all types of injuries that there might be. On the next point, number 2, the first dot point talks about the types of modifications of the workplace that can be arranged, whether it's wheelchair access, non-slip mats. Had a client with a single knee scooter type situation. And interestingly, in that case, the employer didn't really take proper steps to make reasonable adjustments for the employee, and we acted for the employee, and they successfully obtained compensation through VCAT because the employer didn't take proper steps to accommodate the injured worker in the workplace. And so that's a bit of a beware for employers, is that you do have to make reasonable adjustments, whatever they may be, to enable the employee to return to work. And in that case, the employer terminated the employee within their probation period, and the VCAT effectively found that the employer was discriminating against the employee. So again, consider advice from health practitioners, information from the workers, implementation of workplace changes. And I should just say there's no one size fits all to all of these things, because it depends very much on the size of your place of employment. If the employer has 100, 500, 1,000 employees, the expectation on them is going to be vastly different and a much higher level of responsibility expected than an employer with 5 or 10 employees and not having dedicated HR resources. Next, the employer should be assessing and proposing options for suitable employment or pre-injury employment. As I say, the employee may or may not be well enough to return to work in their pre-injury employment, as it's called, or otherwise some other alternative type of work should be found. But it depends again on the size of the employer. If it's a small enough business, there may be no alternate role for the employee, and after the 12-month period in which the employee's employment is held open, it may be that the employee is terminated through redundancy or because they simply can't return to work in their previous capacity. They're just not able to fulfil the essential or inherent requirements of their job. Next is engaging in a consultation with the worker and their treating practitioner and occupational rehabilitation provider. The employee who can't undertake their pre-injury duties may be offered employment that's equivalent to their pre-injury employment. So you've got to look at the pay rates of these alternate positions that are being offered by the employer, access to training and development and career prospects and so on, as opposed to some form of demotion, if you like, which could then leave the employee in a position where they can reject an offer that's not suitable to them, and they could potentially bring legal action against the employer. The last 2 points here, 5 is providing the worker with clear, accurate and current details of their return to work arrangements. And in a moment, I'll show you a form which can be filled out, which is obtainable through the WorkSafe website. And next is monitoring the worker's progress. And again, this comes back to the question of communication, because the employee's condition may change. Those who remember the ads on TV, I think there's a cake that's given to the guy in the sling who comes back on work cover leave, and people are high-fiving them and, oh, great to see you, and all this sort of thing. So I think that that's the picture that the legislation and the government want to create in terms of WorkSafe. In other words, we want to get you back to work as soon as possible, in the best way possible. And essentially, definitely there's going to be cases where it's not suitable for that person to return to their place of employment. And good examples of that are in mental health cases, and we have a number of them and have seen a number of them. And then effectively the employee is assessed as not being suitable at any stage to return to that place of employment. And so then the occupational rehabilitation providers help the worker to find work in another place of employment. They get put into outplacement services to help with their CV and so on, and then moved into other employment. So that can happen. Whereas here under 6, we're talking about getting further documentation from the employee, getting that renewed certificate of capacity with updated information from the employee's doctor, who says now that they're capable of doing more work than they were in the past. They're improving, they're on medication, whatever the case may be. There's a flow chart with lots of colours for those of you that like the flow charts and colours, which just summarises most of the information that we've just spoken about. So that's a bit of a guideline through the process of return to work. And again, we're just giving you the basics. If it comes up, hopefully you'd be able to refer back to this chart as, this presentation as a starting point to give you basics as to what to do in terms of helping employees return to work in your workplace. So there's a return to work arrangements form, which I'll show you in a moment. In fact, I'll just get it up now. Sorry?
Oh, the full thing?
Yeah, the full form I've got here. Can people see that? Is anyone able to tell me that they can see that form? All right, maybe I'll go back to the other.
I'll bring it back.
that's okay. We can just avoid that form.
Yeah. Everyone's muted.
That's okay.
Yeah.
So do I need to go back to slideshow?
Sure.
From current slide, yeah, over here. That one, yeah. No. So there's a form that's available on the WorkCover website, and that gives you all of the steps that you need to think about in terms of helping the employee move back into work. And it would also provide support if anyone brought a claim against the company to show the efforts that you're making to return the employee to the workplace. That doesn't really show you too much of the information, but it's a pretty helpful document. It's got weekly charts so that you can show the different days that the employee might be going back to work, and the hours that they're doing on any given day over a 4-week period. It shows that you can write in the medical restrictions on the person's return to work. You can list the workplace supports or aids that are being put in place for the person's return to work, specified duties which they may need to avoid, and duties or tasks that are to be undertaken. And there's also an explanatory page around that form, so I recommend that to you if, again, you want some basic information about return to work for employees. As I said, there's no one size fits all for any place of employment, and it very much depends on the size of your organisation. Privacy is an important consideration in this because people are obviously sensitive about their medical information. It's not necessarily a good idea to share a person's information with their supervisor, but at the same time, if the supervisor needs to accommodate someone's illnesses of whatever nature, if it's a mental illness or otherwise, then sometimes the supervisor needs to be aware of that in order that they can accommodate that in the person's return to work. So it's certainly showing sensitivity about the sharing of information because in this day and age, I'd suggest that it's a very delicate matter as to people's different medical conditions. And also communicating with your WorkSafe agent and then also your WorkSafe insurer, so your own company insurer who's assisting you and making the payments to the employee, and that just helps the process work smoothly. So the key takeaways here are you can refuse to employ an injured person or allow an injured employee to return to work to protect the health, safety or property of any person. You must hold an injured employee's position open for 12 months once they're on work cover and help them return to their position or modified duties within 12 months of their injury. And that's not always easy, but that's what the law says. And sometimes in tricky areas, you can get some advice, whether that's from work cover or whether you need to get legal advice. Keep in touch and consult with the employee, back to the communication question, contacting their treating practitioner and their occupational rehabilitation provider, and anticipating and preparing for the employee's return to work. So being proactive, making opportunities available for the employee is the best option, because it's said that the longer the employee is away from work, the harder it is and the longer it will take to get them back into the workplace. Assess and propose, we've done that. So keeping detailed written records of steps that you take both prior to and upon the employee's return to work. Obviously, you don't want to contribute to an exaggeration or worsening of the employee's injury once they return to work, and keeping the employee's individual circumstances in mind when preparing for their return to work. Obviously, personal circumstances, family obligations, and matters of that nature. Did anyone have any questions about that? I can just pause for a couple of moments. No? Okay, in that case, we'll move on to mental health and wellbeing. Okay, so mental health in Australia, 20% of Australians aged between 16 and 85 experience mental health in any year, and 45% will experience mental illness in their lifetime. Failure to recognise poor mental health in a workplace has a multitude of consequences in terms of productivity, the person's finances and their relationships, both in the workplace and also their personal relationships, which in turn impacts on the workplace again. Some statistics that came out of the WorkSafe annual report, importantly, had 40% of workers leaving their job because of a poor mental health environment. And also it was expected that up to 1/3 of all cases prosecuted and investigated by WorkSafe over the next 10 years will be because of mental health issues. And I think you just need to read the newspapers and know that it's just becoming a much more prevalent issue. And again, I point to the fact of just being aware of the options about mental health and just treating it largely, albeit sensitively, like any other health issue that is prevalent in your workplace. So employers have a range of duties. We spoke earlier in the return to work and spoke about the injuries, and under the OH&S Act, there's duties. So I guess if you jump down here to some of the points, those duties are under the common law or case law. There's a duty of care that the employer must follow in terms of providing a safe place of work to employees, which includes avoiding the causing of psychological injury to the employee or contributing to that. We touched earlier upon some of this legislation, and you can see specifically Section 20 of the Occupational Health and Safety Act says that an employer has a duty to eliminate risks to health and safety so far as is reasonably practical. That great expression by lawyers, reasonable, what's reasonable? But again, that comes down to the size of the workplace, how expensive it is to avoid certain risks and so on. And, you know, whether you can foresee that a certain type of injury might happen, depending on the type of workplace. If you've got forklifts in your workplace, then someone being hit by a forklift and being seriously injured is an obvious one. But if you're in a book type, office type environment or a school type environment, then perhaps it's more workload and perhaps people being overloaded and not having an awareness of what's going on for people and their ability to cope in certain situations. And the COVID-19 example is probably a good one because in some cases people are isolated in their homes. And so perhaps employers need to have an awareness of how people are coping in their home environment, which technically is the workplace if people are working from home. In addition, the employer's got the duties under the Fair Work Act not to discriminate, if you like, against employees in the general protection sense. Discrimination more generally, both for sexual harassment nature and also in relation to disability of various types, which includes mental health, can constitute a breach of the Equal Opportunity Act, which is usually prosecuted through or brought as a claim through VCAT and also the Victorian Human Rights and Equal Opportunity Commission, which is a bit of a mouthful. And then there's also claims under the Commonwealth Disability Discrimination Act, and additional claims can be brought through the Australian Human Rights Commission. And for example, we've seen some of those claims for discrimination and for mental injury brought. There was an Indigenous player from Gold Coast who brought such an action against the AFL following his finishing with the club based around bullying and discrimination within the Gold Coast Suns football team.
Well, can I ask you a question?
Please, Tim.
In relation to working from home and the sort of workplace safety, I think your previous slide said, you know, we have to as an employer, we've got a duty to do what's reasonably practical. Obviously, we can't assess everybody's desk and their chair and those sort of things. And obviously, it's so new that no one probably would have brought a claim. But are there any general principles about that? You know, someone, particularly given that, so in my case, we've been working from home since April. We'll be at home at least till the end of August, if not the end of September.
Yep.
You know, that's sort of 4, 5, 6 months. You can develop a back or something if you have the wrong sort of desk or chair or that sort of stuff. We've got any obligations in that regard? I know that's probably a pretty tough question to ask, but
I have seen a couple of checklists going around, so you can get checklists in terms of doing an audit of the home workplace. One of the other attendees tonight, I think, comes from a bigger workplace and so probably has done some of these audits. But my view on it is that, for example, so the bigger the workplace, obviously, the more resources you've got to do those sorts of checks. But for a small workplace, whether it's yours, Tim, it's not hard to do a bit of a spot check with the employee in terms of getting out the iPhone, showing it around the room. Talk me through the room that you're in, what's in there, how long are you spending in there, and it doesn't have to be a detailed conversation or audit, if you like, but just having a look at what are the things that are in there. Oh, okay, you've got your Xbox in there, probably not a good idea, for example, but just making sure that there's appropriate space for different tasks to occur, and just those sorts of basic assessments of the workplace. Also understanding people with children and child responsibilities, whether children are coming in and out of the room and things of that nature, and just trying to be as pragmatic and sensible as possible in terms of making suggestions as to what's going to minimise the angst for the person undertaking the work. Now, some people might be looking after the kids during the day and then doing 3 hours of work at night or something like that. So that's a consideration, and that might suit some people, for example. So it's getting that understanding of when people are going to get through their work as well, and then how their workspace works in those situations, and whether it's a closed environment. So if they're working, if you've got an employee who's young and they're in a share house and they've got to work from their kitchen table or something like that, how practical is that? Does the employer need to consider giving some sort of desk space to an employee so that they can set it up in their room, perhaps cheaply, perhaps easily, and allow them that private space to do their work without interruption, and then from the employer you're going to get much better quality work. Those are the sorts of questions I guess I'd suggest. And also, I think just the basic of taking an interest helps provide the employee with a degree of confidence and comfort that there's an interest from the employer. They're saying that one of the big issues is, depending on whether people are in share houses, if they're on their own, it's also taking that interest about doing, as I say, that camera audit just from a bit of a look around and a bit of a chat. Obviously, there's a check-in call in terms of welfare, which can happen every week or two and things of that nature if you're not in regular contact with people. So I think they're, off the top of my head, some of the suggestions I'd make, Tim.
Is there any use in trying to shift the burden, if you like, by sending all of your employees that sort of checklist about what your seat height and desk height is and those sort of, and I'm thinking more in terms of physical ailments rather than mental health issues. Can we protect ourselves a little, at least, by kind of shifting the burden and saying, well, here are the guidelines or the recommendations, and if they don't implement them, then physically we can't go into everybody's house and measure their bloody desk height.
No, I think that makes sense, and I definitely think that you can provide the checklist to the employees. You can ask them to go through and, I guess, tick through the checklist and provide that back to you. And I guess it's safe for you to assume that they've conducted that proper assessment, and you would hope that they'd have a conversation with you if they've got any difficulties with that physical space, but definitely going through that process helps the employer. I think you've got to be careful, of course, to be seen to pass the burden just by providing a document to have the boxes ticked or something like that. As long as you're engaging in a genuine process of discussion with the employee and say, come to us if you've got any problems with this list, and certainly provide us with the list and give us notes as to areas that you're unable to comply with, for example. Then it's a genuine process between the employer and the employee.
Okay, thanks.
Yeah. So moving on, looking at the current guidelines on mental health, employers have a duty, as suggested by the Australian Human Rights Commission, to create a safe and healthy workplace, and we're talking from a mental point of view primarily today. Eliminating and minimising health and safety risks, identifying practices that could be potentially detrimentally impacting on a person's mental illness, taking actions to minimise these risks, and developing a safe and healthy workplace. And the suggestion is that that helps to boost productivity. It fosters a happier and healthier work environment, which is more productive for all, and is more conducive to people wanting to come to work. So quite apart from the legal responsibilities you've got on the side of mental health, it actually helps create happier and healthier employees. And there's always exceptions to that. Sometimes there's toxic employees in a workplace, and you've got to be careful as to how you deal with those and so on. But these are the general principles about keeping your people happy. And obviously we all go through down patches and that sort of thing. Some people have diagnosed mental illnesses and so on. And obviously people don't want to, at this stage, easily disclose having a mental illness. And again, the more we take the stigma out of that, the more it just becomes an injury like any other injury. Yes, I'm working through my depression because of my breakup of my marriage or whatever may have caused that sort of thing, but I'm on the straight and narrow and so on. So, you know, there can be practical and fixable situations that we need to work with our employees to get to the other side with and get back to that great productive employee, rather than losing someone who might have been with you for 3 or 5 years and have a really good helpful knowledge in your business. The Human Rights Commission talks about the legal obligation the employer has in terms of managing the mental illness. So avoiding and preventing discrimination is one aspect. And I suppose what I'd say about that is just having policies that tell people at a basic level that discrimination is not permitted and so on. Where you can, conducting seminars to perhaps explain that in a bit of detail in terms of sexual harassment, inappropriate comments, aggressive talking and behaviour, which can then cause people detriment. And I think we've all seen that sort of behaviour in the workplace, which is caused greater or lesser stress and strain to people who then might have a week or so off work with a medical certificate. And so that's the sort of thing that we need to be proactive about as employers in stepping in on that sort of behaviour. And it's a difficult thing. So I guess I'm introducing these concepts. There's no easy ways, but perhaps seeking advice and doing research on these matters, because of the potential for these things to get much worse and then to create a claim against the employer or having a long-term absent employee. And as the bottom point points out there, you can have an adverse action claim by the employees. I think it's supposed to be by the employees rather than against the employees, including those with a mental illness. So in terms of the current guidelines on mental health, Safe Work Australia puts out the information that's set out in this slide. And I guess it's summarised in the points of preventing harm, and then that's broken down a bit. Early intervention, and highlighted in red is communication. So it's just understanding whether something's a problem, talking to people, observing their behaviour. Have we got someone who's gone from being a happy person to being really down in the dumps and so on, and there's no other explanation other than what's happening in their workplace? So we've got to have an awareness of those things, ask questions, ask other employees who we trust their judgment to say, is there something going on with this person, so that we can take steps to address the issue in a timely fashion. Supporting the person in their recovery, as I mentioned a few moments ago, including taking measures to reduce harm to mental health and wellbeing generally, and providing education, ensuring risk management, putting steps in place, having leadership, whether that's people getting in touch with people and showing by example mentally healthy behaviour, and having open discussions with people about mental health issues in the workplace, so that it opens up the opportunity for discussions amongst staff, that sort of leadership, and all of those things contribute to creating a safe workplace. One of the articles that I read in preparing this was written from the legal side of things, but I think that the points are just as well made no matter what your workplace is that we need to do a number of things that help to maintain the mental well-being. Part of it is building the connections and having supportive relationships. So it's building those connections in the workplace, and in a range of literature that I read, in fact, something as recently as today, it said that loneliness was one of the biggest mental health issues that occurred during COVID in the last 3 or 4 months. So I think you can assume, and they're saying that that's not something that people will just get over once the restrictions are lifted, and they're saying so that we'll see the effects of that probably until the end of the year. So it's helping build the connections with people and fostering supportive relationships. And it may be just putting people in touch with other people in the workplace and things like that, particularly at times like the moment when it's perhaps more important. But ongoing connected people are not lonely people, because to a greater or lesser extent they've got some sense of belonging in the workplace and so on. So in terms of the 5 pillars of wellbeing that have been written about in this article by Mary Jane, she talks about positive emotion, engagement, relationships, meaning and achievement, and I'll talk about those in a moment. And the other point I wanted to make from this slide was the intrinsic rather than extrinsic goals. Rather than saying, okay, I've got a trophy for being the highest sales figures of the month, I've just got a pay rise, it shows how good I am. Those aren't the things that help us be happy in the workplace. The sorts of things that are the intrinsic, what makes us happy. Have we really made our client happy? Have we made the world a better place depending on the type of work that you do? Have I given a loan to someone who otherwise couldn't get the loan if I'm a mortgage broker or whatever it is? What are we getting out of work? What's driving us and making us happy? And so it's that internal goal that's making us happy, rather those external things which might appear to make people happy, but the suggestion is, from a well-being point of view, that's not what makes people happy, even though they might profess to be happy. So I'll leave this slide as well for you to have a bit of a look through the different aspects. So it's helping create these various components in the workplace that make people positive and productive. And I guess it's not a simple thing, but these are the sorts of, and if you like, it's a bit of a touchy-feely sort of thing, I suppose, compared to the concrete things about, I've got a chair that doesn't give me a sore back and things like that. But that's what mental health is about. It's about checking how people are, making sure, stress, overloading people with work, being aware that someone's returning from the passing of their grandmother and perhaps being cautiously kind about the workload that you place upon the person in that 1 week period after they come back from that funeral and so on. Just having that foresight and understanding and cooperation with the employees, and that then drives into other things, and hopefully builds the relationship and trust between the employer and the various employees. There's a few cases that I'll talk through just briefly now. I noticed the time's 6:20, so I won't keep you too long tonight, just by way of example of when things go wrong. And I guess, obviously, we're talking about the positive in this case, and that's why Ines cleverly used the word well-being in the title, because on the other hand, you call it mental health in the workplace. But then from the positive point of view, and I've seen some of these policies, you talk about well-being in the workplace, which is the positive side of mental health. So that's what we want to focus on. But when things go wrong, well-being hasn't been protected. And these cases just illustrate some of what can happen. So in Robinson in the state of Queensland, the plaintiff said that they'd been subject to repeated managerial mistreatment by the CEO, which caused them a psychiatric injury, and that made the person unable to return to work. I talked about the common law or case-based duty of care that's owed, and the employer had failed to take timely and determinative action in relation to the complaints. So we've got to monitor and investigate those complaints that are forthcoming and take appropriate action about dealing with those complaints. And if it doesn't happen, in this case, the plaintiff's complaints, it seems, weren't properly dealt with. There was a failure to act and investigate that allowed the conflict to fester, and the humiliation in the workplace continued to grow. And the law talks about what's reasonably foreseeable. In other words, is it expected that someone would develop a serious psychiatric injury if serious bullying and so on occurred in the workplace? And we all know that we spend more than half of our working life, for those that work full-time, in the workplace, Monday to Friday. So it's a huge part of our life. So if things are going badly, it's going to have a serious effect on us. So in this case, a reasonable employer would have considered the complaints and attempted to at least mediate the situation. And in the case, the plaintiff was awarded $1.5 million in damages. In the next example, Campbell's and Woolworths, the employee developed a major depressive disorder following an investigation that occurred in the workplace. Effectively, and this comes back to talking about privacy before and sensitivity, in the investigation process, the allegations were not kept confidential. And so other staff became aware of the allegations and were saying to the employee, how come you haven't been sacked yet? We heard that you were being investigated. I think the allegations were for theft. And whatever the allegations were unsubstantiated. And even though the investigation was reasonable, it was the leaking of the confidential nature of the investigation which caused the employee's serious medical reaction to the situation, that which was held to be unlawful, and therefore effectively a privacy breach which caused serious psychiatric injury to the employee. Because as you can see from the notes, the person was ostracised at work, their reputation was ruined, and they continued with a serious psychiatric injury. So there wasn't an award of compensation. In that case, the court referred the person off to a psychiatrist, to assess what compensation should be made. But the point being that the employer was liable because of the way they conducted the workplace investigation process, breached the confidentiality and caused the employee's psychiatric injury. The third one is a more recent case And I think I even worked with this person before they became a lawyer. They were in the justice system. And once they became a lawyer, because of a high workload working with sexual offence cases over something like a 3-year period, became very traumatised. The person was a mother of 2, and they were diagnosed with post-traumatic stress disorder and depression because of all of that workload in a very, stressful and depressing type of caseload. And effectively, the Supreme Court of Victoria said that the employer failed to take reasonable steps to protect the employee from harm, and there are a number of measures the employer could have taken through their occupational health and safety system, having proper training with employees about the potential risk of this sort of harm and this sort of reaction. I guess having a process of someone to report to if you're feeling overwhelmed by things, having employees looking out for other employees, and casework rotation. In other words, perhaps moving people out of the sexual offences unit and into other areas of crime, whether it's armed robbery or drug trafficking or something, so that the person isn't overwhelmed by that sort of very depressing or stressful material. And the person was awarded $400,000 damages, both for pain and suffering, namely psychiatric type damage, as well as past and future loss of income. So that's a significant recent decision of the Victorian Supreme Court. There's some other examples there which I've just quickly extracted, which are less about damages awarded to employees, but these are taken straight from the WorkSafe website. And in the first example, I think the company was in Moorabbin or somewhere around there, and there was repeated bullying of staff in the workplace, and 116,000, I think the company's Monjon, 116,000 in fines were awarded against the employer. And in the second case, $7,500 was awarded for the bullying of an employee. And I guess it's just being aware of these sorts of examples and the prosecutions. Not that I think that any of you employers would engage in this sort of behaviour, but having an awareness of what's going on out there and what's being investigated, and I guess just being mindful about employees perhaps being a bit vulnerable to bullying and things of that nature from other employees. So I'll finish with this slide on the key takeaways for employers. Be aware of your obligations to provide employees with a safe workplace. And I think that we all basically know that. We've given a few examples of some of the laws that apply here today. And another example is the Brodie's Law, which is a very extreme case where there was a death in the workplace that the employer contributes to in terms of OH&S, but imprisonment can flow from serious breaches of workplace laws. Employers need to actively support and encourage their employees to take care for their mental health, making mental health a priority in the workplace by proactively implementing policies and procedures, showing a genuine concern to employees, involving employees in discussions about how to promote mental well-being in the workplace, and then if you identify a risk to mental health in your workplace, whether that's bullying, whether that's long hours of work, whether it's very stressful type cases, you must not fail to act to reduce or remove the risk or provide supports to the various employees. And they're some of the best ways to protect yourself and to improve your workplace and to ensure that things don't go wrong. So check in with your employees regularly about how they're coping with their workload and consider reasonable adjustments to support them. And I guess, it's a fine line between prying too much to people about whether they've got a mental health problem or not. People might be reluctant to tell you that they're suffering depression and things of that nature. But then also you've got to be careful to protect other employees as well as those employees. So there's some resources, just the general helplines for people that they can get phone help if they're in a difficult headspace. They can also go for some online information and help in some of those situations as well. So that's about all we've got for today. I hope that gave you all a bit of
sharing your screen.
Yeah.
Sorry, I can't see.
Hope that gave you some idea about a few ideas for the return to work of your employees, and also in terms of dealing with mental health. I should just say the next topic we'll be doing probably in about 2 or 3 months for anyone interested will be around the wage theft laws, and just making sure you're on top of pay rates that are being paid to employees and paying conditions of work and so on, because of the new wage theft laws that are coming in both in Victoria and by the federal government, which carry jail terms for breaches of those laws, and they're very well publicised. But that's I'm not doing a hard sell, obviously, just mentioning that for those that are interested. Is there any other questions before we go, anyone? But otherwise, I hope you've got something out of that tonight. We had another return to work seminar which went for an hour earlier in the year. So just with a nod of the head, is anyone interested in? There's a fair bit in the return to work here, but there's a more comprehensive slide set that I can send to anyone interested.
Yeah, that'd be great.
We're getting a nod. Okay,
I'll
circulate that, and that's got a fair bit of information about the return to work process as well, and the do's and don'ts of all of that. So thank you very much again for your attendance on this cold winter's night. I know, well, you know, you're allowed to go out for a run, I suppose, but other than that, you're not allowed to go too far or do anything. So enjoy the rest of your night.
Thanks, Paul.
Thanks very much, Paul.
Bye-bye.
Thank you.
Thank you. Stay well, everybody.
Thank you.
Thanks.
Bye-bye.
Bye. See you all. Bye.